Good day. Welcome colleagues, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. We are here today to begin our deliberations on Bill 377, an act to amend the Income Tax Act, requirements for labor organizations. This bill proposes to require labor organizations and labor trusts to submit an annual information return, providing certain financial information to the Canada Revenue Agency for public disclosure. It would also impose a monetary penalty on labor organizations and labor trusts that fail to submit such a return. Bill 377 was originally introduced in the House of Commons in December 2011 by Mr. Russ Hiebert, Member of Parliament for South Surrey, White Rock, Cloverdale, and British Columbia. The bill was reinstated by the House at the start of the current session, and this is our first meeting on the legislation. As a reminder to those watching, these committee hearings are open to the public and also available via webcast on the parl.gc.ca website. And you can find more information on the schedule of witnesses on the same website under Senate committees. And for our first panel today, please welcome the sponsor of the bill, Russ Hiebert, Member of Parliament for South Surrey, White Rock, Cloverdale. Mr. Hiebert, welcome to the committee, and you now have the floor, sir.
Thank you very much, Mr. Chair. Senators, it's my privilege to be invited to appear before you to advocate for my private member's bill, C-377. My bill has had an interesting journey to this point. I won't tell you the whole story today, but you might be interested to learn that back in 2011, I was the very first Member of Parliament to have his name drawn for private member's business in this, the 41st Parliament. Now, 4 years later, there appears to be just enough time left to consider C-377, and if you and your colleagues deem it appropriate, pass it and have it become law. And there are a number of solid reasons why you should pass this bill. First, requiring labor organizations to file their financials for subsequent public disclosure would be an important step forward for transparency and accountability in a group of institutions that receive massive public benefits. Indeed, labor organizations in Canada operate tax-free, and their members receive full income tax deductibility for their dues payments and receive their strike pay tax-free. Dues deductibility alone costs the federal treasury approximately $500 million a year. This Senate, in this Parliament, recently passed another piece of transparency legislation titled the First Nations Financial Transparency Act. I believe that with the publication of the first year's reports, band members and the Canadian public have now seen what most bands are, in fact, fiscally responsible, and those that are not are now being held to account. Likewise, with the financial information that Bill C-377 provides, the public will be empowered to gauge the effectiveness, financial integrity, and health of Canadian unions and the value that taxpayers receive for the benefits that they provide. This bill will bring Canada into the 21st century with respect to transparency for labor organizations. Public financial disclosure for labor organizations is already the law in other developed nations and our major trading partners, including the United States, Great Britain, France, Germany, and Australia. In fact, since I last appeared before the Senate Committee to talk about C-377 2 years ago, a Royal Commission in Australia on the Trade Union Governance and Corruption has met and recommended strengthening the disclosure regime there, including posting audited union financial statements on a government website. There is no doubt in my mind that a requirement for public disclosure will help many Canadian unions avoid financial irregularities. Again, in just the last 2 years since I appeared before the Senate on this bill, we've heard the scandalous revelations of the Charbonneau Commission in Quebec, learned of an investigation of theft, breach of trust, fraud, and laundering the proceeds of crime involving executives of the Ontario Provincial Police Union. We've seen a Quebec Federation of Labour boss convicted of fraud for inflated expense claims. Witnessed charges of fraud laid against a business manager of the local International Brotherhood of Electrical Workers in Windsor, in Ontario, and so on. While C-377 will not prevent all criminal activity, it is clear that if the books are published, it becomes much more challenging for would-be criminals to take advantage of union members' money. It is also clear that union members, as well as the general public, want this type of accountability. According to a 2013 Leger poll of 1,400 Canadians, 83% of the general public surveyed indicated that they want this type of law, and 84% of current union members also agree. This poll is consistent with past polls, including a Nanos survey in 2011, asking the same question. Now, let me take a moment to address the critics of the bill. First, some have suggested that it will create a paper or expense burden to unions. However, a significant number of union leaders have already testified both before the House and the Senate in this Parliament, and almost all of them have stated that they already provide this financial information to their members. Senators, if this information is already being provided to members, then there is little to no expense to provide this information to the Canada Revenue Agency as well. Of course, there will be a cost to the government to collect and publish this information. The CRA has confirmed to Parliament that the estimated startup costs of implementing Bill C-377 will be $1.2 million for each of the first 2 years and $800,000 annually thereafter. I believe that this is a modest price to pay to obtain transparency on the use of hundreds of millions of dollars in public benefits. Second, some union leaders have questioned the constitutionality of the bill, so please let me address that head-on. I believe C-377 is constitutional for the following reasons. First, C-377 is only concerned with matters that already fall under the Income Tax Act and have long been constitutional, namely the filing of financial information and the publication of data. For nearly 40 years, the Income Tax Act has required the collection and public disclosure of the same sort of information from charities, and this has never been successfully challenged. Second, C-377 does not regulate the activities of unions, and it does not tell them how to spend their money. Anything they are doing today, they will still be able to do after this bill is passed. Finally, C-377 does not violate any charter rights or the privacy of Canadians by asking for limited disclosure of salary and benefits or for paid time spent on political activities. Indeed, so-called sunshine laws in various Canadian provinces have been in place for decades. And on the issue of privacy, former Privacy Commissioner of Canada, Jennifer Stoddart, confirmed for the Senate Banking Committee on May 29, 2013, that nothing in Bill C-377, if passed, would violate the Privacy Act. While you will undoubtedly hear more legal opinions on these matters, what is clear is the point that motivated Stéphane Dion, the former leader of the Liberal Party of Canada and a constitutional scholar, to vote to allow this bill to move forward when it came before the Private Members' Business Committee of the House of Commons. Mr. Dion recognized the simple fact that C-377 is clearly not unconstitutional. After hearing from all your witnesses, I would urge you to come to the same conclusion that he did, that the questions raised by some about constitutionality are not sufficient justification to prevent the bill from moving forward for consideration by the full Senate at third reading. If you believe in the principles of transparency and accountability for our public institutions, then I urge you to support Bill C-377. Thank you again for inviting me here today, and I would be pleased to answer your questions.
Thank you, sir. We'll begin those questions with the committee's Deputy Chair, Senator Baker.
Thank you, Mr. Chairman, and welcome to the witness, and I'll try to be brief so that others can ask questions. First of all, Mr. Hiebert, you say that it will cost the taxpayers of Canada $1.2 million in the first year of operation if this bill passes. As you know, there's a parliamentary rule. It applies to the Senate. We cannot approve a private member's bill that involves an expenditure of public money. How do you answer that?
Mr. Baker, the Speaker of the House of Commons addressed this matter when it was before our chamber and came to the ruling that the CRA can incorporate into its current activities and under its current budget these kinds of activities. And so therefore it did not require a royal recommendation.
Well, your evidence is that it's going to cost $1.2 million in the first year and $800,000, as I understand it, the year after. Anyway, let's, you know, that involves a parliamentary rule, very clear. My understanding is that there was no amount of money that was determined that it would cost the public treasury when the bill was before the House of Commons.
As I said, the Speaker addressed this question when it was
He
challenged.
did not address the question of $1.2 million.
He addressed the question of the additional cost to the CRA.
When did you find out it would cost $1.2 million?
When the CRA came as a witness before the Senate 2 years ago.
That was after the House of Commons passed.
They testified.
Okay, let's move on. You say this is similar to the system in place in the United States. It's my understanding that in the United States, the system you're referring to only applies to private sector unions. Is that correct?
I believe it applies to a variety of unions.
No, private sector unions, there's a restriction on it. Secondly, the $5,000 only applies to unions that have an income of over $250,000 a year. Is that correct?
That's correct.
There you go. So we don't have a similar piece of legislation. I am interested if you could clarify the wording on page 3 of this bill, in which you say a statement with a reasonable estimate of the percentage of time dedicated by persons referred to in subparagraph 7 to each of political activities, lobbying activities, and other non-labor relations activities. Now, in the previous paragraph, this not only includes persons receiving over $100,000, but it includes, and I quote, to persons in positions of authority with the unions. Now, somebody in a position of authority in a tiny municipality that has a union, this section will apply to them. How would you determine the percentage of time that somebody, a reasonable estimate, spends on political activities and non-labor relations activities in that community? I mean, wouldn't it be rational for that person to say, that's none of your business, how much time I spend working for the Conservative Party of Canada? I mean, normal people would look at you and say, this was settled years ago, many, many years ago. It's nobody's business if I spend on my time working for a political party or for the church or anybody else. But this captures it because there's no parameters in law here. How do you respond to that?
Mr. Baker, this legislation was largely mirrored after the U.S. requirements, and many Canadian labor organizations who are headquartered in the United States currently have to disclose exactly this kind of information. And you can look it up on the U.S. Department of Labor website, as I have, where Canadian labor leaders, workers, lobbyists currently disclose the time they spend on political activities. So with respect to the hypothetical situation that you're applying, in that case, I would imagine that it wouldn't be a great deal of time, and so the answer would be negligible or nearly zero, if anything at all. So do I think that there should be separate standards? Do I think that some Canadian labor organizations should have to disclose their political activities to the U.S. Department of Labor and other Canadian labor organizations do not? No, I don't agree with that premise at all. I believe there should be a level playing field in Canada where all labor organizations have to disclose the same kind of information. And currently, that is not the case.
You're going to have this.
quand même, ça prend du courage pour présenter un projet.
It takes courage to present a bill on unions. My first question, unions and their lawyers. I'll wait until you put on the headphones for interpretation. Can you hear the interpreter, Mr. Hiebert? Do you hear the interpreter, Mr. Hiebert? As it works? Okay, good. My first question, unions and lawyers and certain social workers and militants have gone up against this bill of yours. You obviously know that I was a head of a union for 15 years, and I produced financial statements on behalf of that union for 15 years. I was making public reports and public statements when I was at the head of the association. Is it extraordinary in Canada to ask unions to present public financial statements? And according to you, why do you believe unions are so afraid that we see their financial statements, considering they get all this money tax-free and giving tax credits to those who contribute? Thank you for your question.
It is extraordinary for Canadians to expect labor organizations to disclose this kind of information to them. In Canada, we support a variety of institutions, charities, First Nations, labor organizations. They all receive substantial public benefits. In the case of labor organizations, their benefits accrue to the tune of around $500 million a year in tax deductions. Do I believe that Canadians have an interest in knowing what they're getting for that foregone tax expenditure? Yes, I do. As I said, we do it for charities. We've now recently extended it to First Nations. For many years, we've extended it to federal, provincial governments, crown corporations, and we've learned that transparency and accountability is good for the institutions that serve the public. We know from polling that Canadians want this kind of information, repetitive polling, where they've said 83% of Canadians have repeatedly said this would be good for the country. So the fact that we're currently doing it for some institutions also demonstrates support. In the case of charities, for nearly 40 years, they have had to disclose information like this. That's put on websites that the public can see. And so when they donate to these charities, they can have some sense that their money is being well spent because there's some accountability. And I believe the same rationale applies to labor organizations. When the government, when the Canadian public foregoes so much money to support these institutions, and rightfully so, nobody's questioning that, there is a subsequent or a reciprocal obligation on their part to provide at least some information. We're not asking for everything. We know there are exemptions, that we can get into, but just some information as is currently required by the U.S. Department of Labor. And this is what really got me started at the very beginning, is when I found out that some Canadian labor organizations already disclose this information and have for years, but to no Canadian source, to the U.S. Department of Labor. So when I looked them up, I was like, well, why is this the case? Why would they not also have this kind of disclosure in Canada? And that's the purpose behind the bill.
Avec votre permission, Monsieur le Président.
With your permission, Mr. Chair, Canadian unions are they so involved in politics as we say? And if so, do they do it with the full support of their members? I'm going to ask you my second question right away as well. The investigation currently ongoing on the Ontario Police Union, does it reinforce the basis of your bill? Obviously, you spoke of what happened in Quebec with the Charbonneau Commission and FTQ construction. It doesn't take too many examples for us to realize that at a certain point transparency is essential, and these two examples are very clear ones. So, Mr. Hiebert, your answers.
Question. I think Canadians don't know how much unions are involved in political activity. And we have hearsay. We're able to determine some information to that effect because of the disclosures on the U.S. Department of Labor website by Canadian labor organizations. But we really don't know to what degree they're involved, and the members don't know to what degree they're involved in political activities. So this legislation would, provide some indication. It puts no restrictions on that involvement, no barriers, no regulation. It simply requires information, to let the public know what they're involved in, as we currently see on the U.S. Department of Labor website. With respect to the Ontario investigation into the Police Association or the FTQ construction in the Charbonneau Commission, these are things that have transpired since I introduced the bill. And some people have made a connection. I've always been of the opinion that the purpose of the bill is to gauge the effectiveness, accountability, and health of these organizations. And I've always made the presumption that whatever Canadians would find would affirm their confidence in these institutions.
As you sum up.
These might be exceptions, and I expect that they are exceptions to the rule, that this kind of legislation would likely help identify, but I would believe that overall we would find very positive support for unions through their disclosures.
Senator Ringa.
Thank you, Chair. For the members of this committee that are listening to this issue in committee for the first time, I'd like to say that Senator Bellemare and I are the only one that have gone through the process a few years ago in the Senate Banking Committee. And I guess that from my files here, that you will see that extensive research have been done, including, and I would like to take the opportunity to make a few corrections from our witness statement. And the first one is in regards to the constitutionality of the bill, and the witness stating that Stéphane Dion had agreed to this bill as a member of a subcommittee. Let me read a letter signed by Mr. Dion to Senator Gerstein that was filed on June 5th, 2013 in regards to this issue. And it goes, and the second paragraph is as follows. Bien que je sois flatté par la confiance.
Even though I am flattered by the confidence that my colleagues demonstrate regarding my constitutional expertise, I must tell you that the subcommittee on private members' business bills and the procedural affairs committee is not a constitutional court. It does not do a profound analysis, an exhaustive analysis of bills. All we do there in that committee is to assess whether a bill deserves to be debated and voted upon. And he ends the paragraph by saying quite the contrary. That means that the constitutionality of a bill is a legitimate object of debate between parliamentarians. In other words, it was not a constitutional it wasn't a support for the constitutionality question. I want to also make a comment about the cost here. Revenue Canada indicated that the cost of implementation would be of $2.4 million for 1,000 such organizations to submit statements. If you look at the number of organizations that will have to file information returns, because we're not only talking about unions or labor organizations. If you look at the definitions in C-377,
Selon
according to the PBO, the Parliamentary Budget Officer, he mentions a cost of up to $60 million for the first year. That is a considerable sum.
to be cleared on very important statement that was done by the witness. Now, Mr. Hiebert, You said that transparency, effectiveness, accountability, and the taxpayers needed to receive information in regards to tax breaks. Do you believe that should also be the case for businesses that get tax break? That are involved in labor relations?
Is that your question?
Yes.
Okay. I'd like to start by addressing the earlier comments that you made. With respect to the Subcommittee on Private Members' Business, they have several criteria that they use to evaluate whether or not a private member's bill will proceed for general consideration. And one of those questions is the bill clearly not unconstitutional? When Mr. Dion was challenged by an NDP member of the House of Commons on this question, he voted with the majority to allow the bill to proceed because it obviously passed that criteria. Otherwise, if it had not passed that criteria, he would have voted contrary. So that's what I'm referring to when I say that there's support from Mr. Dion. At that stage, he clearly did not believe that it was an unconstitutional piece of legislation. Otherwise, we would not be here today. Regarding the cost, I believe that the estimates provided by the PVO are far less relevant than the estimates provided by the actual ministry that has to implement this piece of legislation. And they did come and testify before a Senate committee and indicated, as I said, the first 2 years would cost about $1.2 million per year, and then it would be about $800,000 thereafter. And I think that's really the relevant information. The rest is simply speculation. In terms of corporations, I've frequently been asked, why does this bill not apply to other institutions? And the simple answer is I'm focused on this category of institution, just like in the past, legislation was brought forward to focus on charities in 1977. And since then, they've had to disclose. More recently, the First Nations Transparency Act focused on that type of institution. And now they have to disclose. In this case...
Senator Platt.
Well, thank you, Chair. I'm not sure which witness I should be asking the question from right now. But I think I will focus on the official one, Mr. Hiebert. Mr. Hiebert, thank you for your tenacity in working with this bill as long as you have, and I believe it is now time that we finally put this to rest and make this bill law. I appreciate the work you've done. Now, we have a couple of police officers here, and the sponsor of the bill was the head of a police association. My question, however, is still around the police associations, and you and I have talked about this in the past. Some of the members of police associations around the country have raised concerns in regards to safety. So my question is, have you met with members of the Canadian Police Association, and if so, could you talk a little bit about their concern and assure the committee that this bill in no way jeopardizes the safety of the police association members?
Thank you for the question, Mr. Senator Platt. So when the bill was in the House of Commons, yes, we did hear concerns expressed by the Canadian Police Association, and yes, we did meet with them to address their concerns about the disclosure of exposing sensitive identifying information. And that is why we brought forward amendments to satisfy that particular concern that they had expressed at that time. And I believe that, since that time, since the amendments have been put in place, they are content with that element of the bill. They may not be satisfied with the bill in its entirety, but with that particular element. I do note, however, that there are many police unions in Canada that already publish names, including, in some cases, photographs on their own websites. And so my amendments to the bill address that issue, but the broader concern about whether or not those kinds of individuals should be disclosed publicly, it remains. It's still out there.
Thank you. One more question, if I could, Chair. The NHL Players Association have also raised some concerns. And again, same question. Have you met with the NHL Players Association and have you addressed some of their concerns?
I have not met with them. I've not received a request to meet with them. This is the first I'm seeing of this. I've heard of the concern from other members, and all I can say is that, we're not here to pick and choose which organizations should be required to disclose. The definition of a labor organization is drawn from previous case history and previous legislation, and is fairly all-encompassing. And if they fall under the definition, then so be it. But the broader purpose of this bill is to provide transparency and accountability for these kinds of institutions.
Because of political activity, and they say that they would not be involved in any partisan political activity.
If that's the case, then their disclosures in that particular area would be nothing, would be zero.
Thank you. Thank you, Chair.
Thank you. Senator Jeffer.
Thank you, Chair, and thank you for your presentation. And I want to go on something completely different. And knowing that you're also a lawyer, I would like you to address the issues that have been raised by many under the Charter of Rights and Freedoms, the issue under 2B and 2D, guarantee of freedom of expression and guarantee of freedom of speech. Do you have any concerns that does this bill comply with the Charter of Rights and Freedoms when it comes to 2B and 2D?
I believe it does, yes. I believe that the fact that the bill specifically exempts labor organizations from detailed disclosure about their core activities addresses that issue. I believe that requiring them to disclose the gifts that they give or traveling to conventions would not inhibit them in any way from associating or their expression. And the fact that the bill does not regulate them in any way, as I said in my opening statement, that if this bill was to pass, unions could continue to do what they've been doing. They simply have to disclose some elements of what they've been doing. Because it doesn't regulate them, because it doesn't inhibit them, I do not believe it would be subject, or it could be subject to, but I do not feel it would fail under a charter challenge in that respect.
Mr. Hiebert, I have a question, further to what Senator Baker was asking you about on page 3, clause 7.1. Can you define what is other non-labor relations activities? What is your definition for that?
Well, the bill itself does not have a definition of other non-labor relations activities. And, I mean, to some degree, that would be left to the CRA to provide more specific guidance to the detail of what that would mean. But, I mean, a straightforward reading would be it's labor relations activity, it's non-labor relations activities.
So would that cover a scout leader working in your church? You drafted this. And so I'm asking you, how could you tell any person in Canada to set out what their non-labor activities are? Working in the church, being a Boy Scout leader?
As I said, Honorable Senator, when it comes to the specific examples that you're providing, I believe that in that case, if there's an institution that falls within the definition of labor organization and they have that particular question, that's a question that they could put to officials at the CRA. But as we all know, in legislation, you cannot anticipate every hypothetical situation and cover it off. You have to provide, general guidance. And the language that we've used in this bill is consistent with the language used within the Income Tax Act and the definitions used in the Act. And it's similar to the law as it was drafted back in 1959 and updated in 2004 in the United States.
Senators, we have a little under 15 minutes, and I have seven questioners remaining, and I want to encourage all of you. I know it's a challenge at the best of times. And to our witness as well, please try to tighten up your responses to questions. That would be appreciated. Senator McIntyre.
Thank you, Chair. Thank you, Mr. Hiebert, for your presentation. In perusing Bill C-377, my understanding is that the $5,000 disclosure threshold does not apply to the core functions of a labor organization. For example, if the funds were expended for administration, overhead, labor relations activities, my understanding is that then only an aggregate figure would be supplied for all spending in those areas. However, on the other hand, in the case of related party transactions or conflict of interest or involvement of a labor union in lobbying or political activities, full reporting on the details of those transactions will be needed. Am I correct in this assumption?
The bill specifically exempts those core activities of a labor organization. In those instances, they simply have to disclose an aggregate amount.
In other words, a lump sum.
A lump sum.
Yes. They don't have to get into details.
Correct.
Yeah, okay. Does the bill require audit statements?
No, it does not.
It makes no requirement that the filing be audited, for example. You know, my understanding is that the only activity required by the bill is the filing of an information return.
Correct.
Okay, thank you.
Senator Fraser.
Thank you, Chair. Mr. Hiebert, welcome. In your opening statement, you and Senator Dagenet and numerous other supporters of this bill have mentioned the Charbonneau Commission as an indication that there is a problem of corruption, I guess, in unions that needs to be tackled. I'm a Quebecer. I paid attention to the Charbonneau Commission. I note that we do not have its report yet. But I also note that among the witnesses who provided very troubling testimony, if memory serves, a greater number were employers than representatives of unions. You say this is a sector-specific bill, but in fact, unions exist in a unique circumstance in that they exist as part of a, if you will, matched set. They exist to function in an adversarial relationship with employers. Why are you not demanding that employers also give this and make public, not just give to the CRA, but make public this extraordinary degree of detail down to the purpose of every single contract of $5,000?
Thank you for the question, Senator Fraser. As I indicated in an earlier answer, I believe that when you deal with organizations, you have to recognize that they operate differently, just as charities operate differently than labor organizations and First Nations operate differently than charities. I believe corporations operate differently than labor organizations. And I would not be opposed to someone of my colleagues or from your upper chamber from bringing forward similar disclosure requirements for corporations. I'm simply here saying that what I discovered and identified was that some Canadian labor organizations have to disclose this information and others do not. And the ones that do don't have to disclose it in Canada, but they have to disclose it to the U.S. Department of Labor. And I think that if Americans deserve this kind of disclosure, so do Canadians.
Senator White.
Thank you very much. Thanks for being here today. I'm start by saying I'm all for transparency. But in response to your comment just now, those who do have to respond to it in the United States, as an example, don't have to do it in accordance with the Income Tax Act. They have to do it in accordance with what law?
They have their own LMRDA.
It's under labor law.
Yeah.
And the challenge we would have in Canada, I take it, is that labor law is not federal law, it's provincial law.
It's provincial, correct.
So are any provinces today in Canada already, or do any provinces in Canada today already have instituted such a regime under their labor law?
7 of 10 provinces require some degree of disclosure under labor law of differing amounts to members. But you have to remember, this bill is about disclosure to the Canadian public, because it is the Canadian public that is supporting these institutions to the tune of $500 million a year with tax deductions.
If I may, Mr. Chair, and I understand and I appreciate it, and I want to start again by saying I'm a believer in transparency, but I'm also a believer in ensuring that legislation is brought through in the appropriate, developed under the appropriate laws. And I guess the only concern I have, and the convincing I need, is that the labor law is not the place this shouldn't be dealt with provincially rather than the Income Tax Act federally. That's my challenge, and to be fair, I'm not sure that when you use the U.S. as an example, and yet the U.S. does not use their Income Tax Act as the sword in this case, instead they use labor law, which in the United States is federal. I'm not sure that it satisfies me. Thank you. Sorry,
Can I comment, Mr. Chair?
Yeah, please, I'd
Very
appreciate
quickly,
it.
please.
The simple point is that we require other disclosure by organizations through the Income Tax Act, like charities, and that's why I believe it's the appropriate place for disclosure.
Senator Joel.
Mr. Hiebert, I met with the representative of the NHL Players Association, Mr. Fair, 3 weeks ago, and the way he explained to me his case was very genuine. He said to me, we enter into licensing agreement with third parties to sell the images, the cards, the jersey, the video game, and all the paraphernalia that accompanies, the NHL activities in Canada. And we know all Canadians, especially those weeks, have their attention focused on that. He said, we were caught by this bill, I'm sure unintended, but nevertheless, we are in there. And we would seek an exemption to this bill because quite obviously our activities doesn't compare to the activities of the union. So he said, we think that there should be an exception and a clause to recognize exceptional circumstances whereby an association like us will not be caught by the definition. And he said, I think it is proper to request that, considering that it would not jeopardize the objective of the bill. Do I understand that you would support such an exception clause in the bill, or you're saying, so be it, as you said in an earlier answer?
I would not support a particular amendment to address a particular issue. I think we have to look at the broad situation. And I simply want to note that I have heard no similar concern expressed by other professional sporting organizations like baseball or basketball. So I'm not sure why we would even entertain an exemption to one professional sporting body and not the others.
Well, maybe, when the debate took place in the other place, that's the way Mr. Fair mentioned it to me. He said we thought it was so much concern about union, traditional union, that we didn't think that we would be caught by it. And I'm sure that if you canvass the other national, Players Association of Sports, and they will find themselves exactly in the same position than the Hockey League, I'm sure that they will concur in the same conclusion that because of the propriety rights that they negotiate with third parties in relation to the players, whatever the players may be, they will find themselves exactly in the same situation. And again, it's not to avoid, I should say public interest, transparency, and all the objective that you explained to us being, the objective of your bill. I think that there is a genuine concern here that there is third-party agreements that should be protected by the privacy that normally, in the business of trades of images of players and all the likes, that should be recognized. I think to me, it falls under sense. And I'm surprised to realize that you're not open to some flexibility in your bill.
Well, as I said, it's interesting that other professional sporting associations don't have the same concern, and they also operate within the United States, and the definition is very similar to what is applicable in the United States, and so if the concern was here, you would expect it to be in the United States as well, and it's simply not one that's come to my attention.
Senator
Thank you very much, Mr. Hiebert, for being here, and congratulations on all the work that you have done to bring this bill to this stage in your now 11 years, I believe, that you've been a member of Parliament. Just picking up on the U.S. example, and I understand that a number of other jurisdictions as well, including the United States, already have legislation in place establishing similar financial disclosure requirements. We've discussed that a little bit so far today, but I just wanted to give you a bit more of an opportunity to tell us a bit about that experience and have disclosure laws worked effectively in those jurisdictions. What has been the impact on labor unions? Has it destroyed labor unions?
Thank you for the question. So as mentioned, virtually all of our trading partners, the G7 members and others, have similar union disclosure requirements. UK, of course, the United States, after which this bill is modeled, France, Germany, Australia, and my research has suggested that labor organizations are strong in those countries and have not suffered adverse effects, whether in negotiations or in any of the other elements of their service to their members as a result of requiring them to disclose information to the public. So we have, an experience in a variety of other countries over a lengthy period of time, none of which suggests that it's a problem. And we have Canadian labor organizations that have had to disclose this information to the U.S. Department of Labor for many years and have not objected to those requirements. So why we don't require those same institutions to disclose in Canada and incorporate the other ones that have not had to disclose, that's what this bill is here to address.
Senator McInnes?
Yes, thank you, Chairman, and thank you for coming. It's been an interesting bill and a long journey for you. I agree with transparency, particularly when it comes to union members. But I want to ask you a question because we read this in the papers and so on. Is this bill more about going after unions for some kind of frontal attack to get at unions? And is it more about exposing any third-party involvement that may be in the form of dollars being contributed to political parties to influence the outcome of elections?
Thank you very much, Senator McInnes, for the question. I have said from the very, very beginning that I believe that labor organizations play a very valuable role in Canadian society and are worthy of the support that the public provides them through the tax deductions that we do. They assist in providing a healthy environment, proper compensation. And so, no, in no sense should this bill be construed as anything other than an opportunity for labor organizations to justify and to demonstrate that they are healthy, that they operate effectively, and that Canadians can have confidence in the work that they do.
I'm sorry we've exceeded our allotted time. I'm sure we could go on for a much greater length of time, but Mr. Hiebert, we have to thank you for being here and putting forth your case. Very much appreciated, and members will suspend briefly.